So at worst, at best, it can only be a 4-point roster.
For according to you, an annual roster is the ideal answer to this situation.
Right. It is the answer, not my suggestion. That is what Malik Mazhar says. That is what para 29 of All India Judges case decision says when it said roster. But it said 40-point roster. I'm not able to understand how the 40-point roster would come in because there are only three sources. Two for promotees, one for direct recruiting, one for LCD. And therefore LDC, and therefore there is no question of a 40-point roster. Many of the high courts have said 4 plus 4 plus 4 plus 4 made it 40. It's not necessary. It's a 4-point roster. According to me, it's only a 4-point roster. And then your lordship finds ideally, I would suggest what should happen is the promotees, they having been in service, give them the first 1, 2, and then 3, the LDC, and the 4th, the direct recruitee. And therefore, there is no chance of people being bunched together to deny the legitimate aspirations of those coming lower. This is what para 29, which when it spoke of the roster said, though I must confess the 40-point roster usage of that expression does not appear to be very correct. 40-point roster would come only where the constitutional reservations come. Here, a roster. Read the 40-point roster as only a roster. And in that roster, the purpose of the roster is very evident. Don't bunch people together in one. You give them this 2 plus 1 plus 1. That is the purpose. And if that is followed, my respectful submission will be all the assumed difficulties, imbalances that are there will vanish. And as pointed out by the Allahabad High Court, it is vanishing also. It's not necessary to do that now. It's already done. It's already done. It's being followed. I'll take a lordship the Kerala rules and again try to convince your lordship on that. Your lordship, and therefore, what is required is the 40-point roster will now be, because there was one 10%, 65% and 25%, there was some confusion. Right now, after the last judgment by this court, all that is required is it has to be promotee 1, promotee 2, LDC 3, and direct recruitee 4. As simple as that.
Yes.
For this, is it necessary to amend the rules? Is a question I would request my lords to consider. And my humble submission will be kindly do not do that. It's not necessary at all. Right.
Thank you.
No. Sorry. I'll complete now. Your lordship finds the other aspect will also be urged. Now, your lordship finds the question is today the fact scenario is very, very different. Direct recruitee 25% also these people can get in. LDC, your lordship.
That is already argued, Mr. Sinha.
Yeah,
There's no point in again repeating the same argument.
Right. I just want your lordship to be reminded of that because
So that has been argued time and again that now the dynamics have changed.
it was very, very
We also
different.
have argued that.
That's what I said. Direct recruitee 25% also these people can get in.
Your lordship,
LDC, your
That
lordship.
is already argued, Mr. Sinha.
Yeah,
There's no point in again.
Now the
repeating
next question
same
is, my
argument.
lord,
I
from the
just want your
entry
lordship to be
grade
reminded
district
of that
judges,
because
So
when
that
they
has been
go
argued
to
time and
the
again
next
that now
higher
the dynamics
of the
have changed.
selection grade
very,
and
very
the
different.
super time
Also
scale,
argued that.
what
That's
happens?
what I said.
Direct
That's the
recruitee
next point.
25%
Your
also,
lordship,
you can kindly have a look at the Kerala
Your
rules.
lordship,
LDC, your lord,
That is
Kerala
already argued,
rules
Mr.
from the,
Sinha.
from
There's no point in
the,
again
now the
repeating
next
same
question is, my lord,
argument.
from the entry grade merit judges,
So that
when
has
they
been
go
argued time
to
and
the
again
next
that now
higher
the dynamics
of the
have
only
changed.
merit selection
I
grade
want very
and the
clearly
super
follow
time
the
scale,
rules that-
what
That's
happens?
what I said.
If at all 25% also, you can kindly have a look at the Kerala
Your
rules.
lordship,
LDC, your lord,
That is
Kerala
already
rules
argued.
from the, it is
There's no
only,
point in again
now the
repeating
next
same
question is, my
argument.
lord,
Please
from
see
the
that.
entry grade only merit judges, because
So
when
that
they
has been
go
argued
to
time and
the
again
next
that-
submitted by the Kerala High Court, isn't it?
So,
I can read, yes. Your lordship, it says, it speaks like this, madam. Appointment to 35% selection grade posts in the service shall be made by the High Court with effect from the 1st January 2020 from amongst the members of the service on the basis of, now comes it, merit and ability, seniority being considered only when merit and ability are equal.
But that is broadly same criteria everywhere.
Yeah,
Merit is the first emphasis.
yeah,
Seniority only determines the zone of
right.
consideration.
Madam.
Rest is the ability and
No,
suitability.
your lordship, from all the next, I wanted to read the next line also.
That's why
Next-
Madam
next-
Maninder Acharya
only-
points out
only approved probationers with 5 years service shall be eligible for being considered for promotion. So that whoever has completed 5 years is eligible to be considered. Forget about where you come from, which stream, all of them are eligible.
Mr. Prasanth, we don't think that there is a single high court having criteria of seniority cum merit or seniority cum fitness or seniority cum suitability. Every high court has merit, then cum maybe ability, maybe seniority, maybe suitability, maybe anything. But first emphasis is on merit. So selection in promotion quota has to be there purely on the basis of merit. Seniority will be only for the limited purpose of identifying the zone of consideration. That's all.
Right, my humble submission would be, and therefore, the grievance that we are lower in the seniority list is not going to affect your movement upwards to the selection grade or thereafter. That's what I'm trying to point out. So that your lordship finds, well, how it is being enforced, your lordship may clarify that it has to be purely on the basis of merit. And pursuit of excellence is an axiom under 51A or the fundamental duties also. And therefore, your lordship finds, in the light of the rules that we have in Kerala, which identical rules, if your lordship wants, the others can be asked to, and it can be directed that strictly this movement from entry point district judge to selection grade shall be only on the basis of merit. And therefore, what happens is the question of seniority lapses into insignificance. You don't have to upset the seniority for this purpose. They would still be on top if they have merit and ability. So that where is the need to amend the rules to accommodate something which is already there? If they are good, if they are meritorious, they come up. There are many sources by which they can become the entry cadre district judge. From the entry cadre to the next higher level, selection grade, it is going to be only on merit, and therefore your seniority does not matter at all. And therefore, to give you a position in there, it's not necessary to amend the rules at all.
Yes. What next?
Yes.
That's all.
Now, the same position relating to movement from selection grade to the next grade also.
But-
That is the super time scale. Now, my lord, can I take your lordship through the Kerala rules one? The Kerala High Court's affidavit. Please see that affidavit, my lord. What is the position in Kerala? Is it necessary to invoke the 142 powers to interfere with something that is happening in Kerala? Yeah.
As my learned brother pointed out, that we are not considering state-wise position.
Emila? No.
Not considering state-wise condition.
No, I want to point out that if no amendment to the rules is required, the rules presently enforced is sufficient. Now, if at all your lordship feels it is necessary, extend this rule to other places is what my humble submission would be. Your lordship finds an amendment to the rule to provide quota, amendment to the rule to provide weightage is not necessary at all, and maintenance of separate seniority lists are not necessary at all, because the malady which we are trying to cure, the solution is already there.
In the Kerala rules.
Yes.
So you want the Kerala rules to be model rules to be followed by all these.
All the
Now, my lord, if your lordship feels that such a clarification will be given so far as the others are concerned, please do that. Please do that. Please make it clear that the seniority shall be on the basis of the order of appointment. Now, the order of appointment will get posted according to the roster. And now thereafter, the promotion from there will be not on the basis of the seniority at all, but purely on merit. And if that is so, there can be no grievance. Now, we don't want to promote somebody who is not meritorious and go to the selection grade. Only those who are meritorious must go in. Your lordship finds the want of merit cannot be used as an excuse to go up the ladder. Because your lordship finds from the entry cadre promotee district judges, your lordship finds what will happen is all of them, all the entry cadre, they are people who have not qualified for, they have not come for direct recruitee as per the last decision. They are people who have not succeeded in the LDCE. For them, who have not got into the selection grade, for them to protect their interest, please don't think of an amendment to the rule. It's not necessary at all.
You have understood that.
You understood?
Yes.
Thank you.
No, just one. I just wanted your lordship to see the Kerala situation as reported by the High Court. Will your lordship kindly see paragraph 7 of the Kerala High Court's affidavit?
Mr. Giri has already pointed that out.
Yeah.
I read out the affidavit.
Yeah, he has read out the affidavit.
Now, what is of importance is, my lord, the statistics given there shows out of 30,
So that was read to us yesterday by Mr. Giri.
yes, 80,
He has already read it to us, his affidavit.
right. I just wanted to bring it to your lordship notice again so that it stays with your lordship, because it is important so far as the Kerala rules are concerned. They do not result in the apprehensions which are aired by the amicus. That is what I want to point out.
So that is already pointed out to us by the learned senior counsel appearing on behalf of the High Court of Kerala.
High Court, unfortunately did not take a specific stand as to whether this should be there or that should be there.
Rightly, because the High Court can't,
I can't do
You know,
High Court can't, but
why, what
the
is,
actual position was pointed out by the counsel.
what is just and fair, the High Court must have the guts to.
So how could the High Court afford to take a particular stand that they are promoting,
No, I will-
they are supporting promoting or they are supporting direct?
I will not say that, but it is up to the High Court to take a stand on what is fair and just. We can't avoid that. We can't avoid that responsibility. And it's for the High Court to point out to the court, as they have done in this, and analyze and show that the apprehensions of the amicus are non-existent in Kerala. That is what I wanted to point out.
Yes, thank you, Mr. Basu. Thank you. Who is next?
I am also in the same application, though my sequence is in the end, Milord. I may be
So
also.
in one eye only one counsel can argue. So your name is there in some other eye.
I just wanted to apprise this court that I am in the sequence in the end, Milord, though I am also representing few of the direct notice, the same application.
So
I wanted to.
insofar as one application is concerned, only one senior counsel can argue.
I am also there, therefore yesterday I said I am with him, Milord.
Okay, that's it.
That's why I said yesterday. I am-
What
Your presence is marked.
Yes.
What has happened is, my lord, there were 7 applicants. I continue with 4, 3 have gone to others. And
That's the reason I said.
that's why he is coming out. 7 applicants originally,
You are not appearing for anybody from Punjab and Haryana.
No, Milord, for the timing I am.
and
South only, Milord, but not so far.
So South has been,
I'm trying to, Milord.
that's all.
Thank you, Lord.
yes, Mr.
May it please, your Lord. Lord, I am appearing in IA number 260414 of 2025 for the direct recruits in Delhi. Now, my Lord, I have 3 or 4 submissions to make. I adopt what has already.
You have also shifted venue.
No, my Lord, actually, by the time the Punjab people came, I had already appeared for Delhi, so I could not appear for the other side in Punjab. But what I am submitting, I am going to submit, I am adopting what Mr. Dwivedi said and what has been argued earlier. But I have 2 or 3 particular submissions to make on one argument address, whether weightage of any sort is necessary to be granted or not. Second, on the roster system, which according to me is a very good system. It has not failed, but it has not been given a chance to operate properly. And my third submission is going to be on the quota, which cannot be granted. Much has been said. I just want to refer to 2 paragraphs. But before I come to that, my Lord, please have my written submission, just 2-3 paragraphs to show that Delhi actually presents the other end of the spectrum, as which the learned amicus pointed to your lordships. It is volume 2, R1, page 1 to 9, 1 to 19.
So then what is the reason? If certain states, it's dominated by promoting, and if it's certain high courts, it is dominated by directs, then some rationalization would be in your benefit.
So my submission is going to be, my lord, that the 2002 judgment in para 30, while rejecting the argument of weightage, introduced a concept of roster. And para 30 weightage is rejected by saying roster will take care of it. Now, unfortunately, in the working of the roster, there have been 1 or 2 problems. And the main problem is the delay in the selection process of the direct recruits. On account of the delay in the selection process of the direct recruits, this roster could not work properly, because what then happens, and what has been following from your lordships, is promotee comes in, say, year 2007. Process of direct recruitment also commenced in 2007. It is completed in 2009. By the time the direct recruit comes and then makes a claim that I should be given a seniority from 2007, it perhaps becomes a little too late in the day for it to be granted. And then your lordship's judgments have also leaned in favor of length of service. This is what happened in Delhi, in B.S. Mathur and the two earlier judgments, even though the rules had rota quota, but because of delay in direct recruitments, the court ultimately said, no, let it be length of service. But all that, I'm just wanting 5 minutes before that, please have this volume 2, R1, page 1 to 19. Now kindly have first internal page will be 2 and running page will be 4. There is a para 6. Your lordship got
The factual position.
factual position in Delhi is just 2-3 paras. I'm not going to dwell much on. The factual position in Delhi is that promotees far outnumber the direct recruits in the post of principal district judge, since out of 12 posts of principal district judges, 9 were promotees and 2 were direct recruits. Please turn over the next page, my lord. This first column is direct and then promotee. So there are 4 direct in 2022, 7 promotees. And if your lordship will go down the chart, my lord, in January 25, there was no direct principal district judge. And now there are 2 and 9 are promotees. Now, please have para 7. The factual position in Delhi is also that during the period 20 to 25, 17 judges from the district judiciary were elevated to the Honorable High Court of Delhi, out of which 15 were promotees and only 2 were direct recruits. Then, my lord, we have said the situation in some other state also remains the same. Of course, your lordship has a much better chart given by the amicus, which Mr. Dwivedi read. Those 13 states, I don't need to read it again. He has given that better chart. Now, my lord, as so far as age is concerned also, if your lordship will come to page 6, running page 6, para 10. The factual position is that the average age at the time of appointment as district judges for both promotees and direct recruits is similar. The average age of appointment of both direct recruits and promotees is in the range of 40 to 41 years. There are instances of promotees being appointed even before the age of 35. We have 3 such people who were 34 years and plus when they became. There are numerous instances of promotees becoming district judges between 35 to 38 and 38 to 40. Then, my lord, I will not read the whole of it. So age also is the same in Delhi. Average age is 40 versus 40.6. So promotees are negative by 6 months only. And I have that chart. I will give it to your lordships, my lord, but your lordship may take it. Now, we have said in some other states also, the position remains the same. So far as Delhi is concerned, the promotees actually are taking a larger share, both at the stage of principal district judge and also at the stage of high court. Now, one other point which I want to point out is at page, because this will then, in the course of arguments, I will be referring to these facts, page 16 running, page 14 internal, para 28. In fact, if I can start from page 13 internal.
Paragraph.
Para 27, that fresh para, last 3 lines at the bottom. It is submitted that whereas appointment of direct recruits against vacancies for a particular year is delayed due to administrative process, on an average, the process takes 2 to 4 years. However, promotees are appointed speedily upon arising of vacancies. Now, here that roster will come, and what my lords were, Justice Suryakant had also observed, that will it be yearly? Why should they get the slots? There are rational answers to that, my lord. I will attempt to give them to your lordships just after I finish reading this. Now, promotees are appointed speedily. As a result, between the period from arising of vacancies and initiation of the recruitment process for direct recruits to the eventual appointment of the direct recruits, several batches of promotees get appointed. In such situation, the application of the rule for determining seniority from date of appointment works in a matter which is grossly unjust and unfair to the direct recruits. Now, we have given instances, my lord, the recruitment notice of Delhi, which was issued in December 13, the left-hand side column, final result is declared in July 15, and direct recruit is appointed in September. In the meantime, in the year 13 itself, 52 promotees came and joined. This is page 14 internal, my lord, in the chart.
Yes, yeah.
Yes. Now, similar is the position every year. Now, in the 15 recruitment, the result is declared in 17 and the direct recruits come in May 2018. And during this time, 47 officers are promoted from 16, 17. And then, my lord, in 17 again, direct recruitment, final result is issued in 2020 and direct recruits are appointed in 21 and 87 officers are promoted during this period from 17 to 20. So that is one problem. Now, my lord, in my respectful submission, this problem can be solved if there is proper and honest implementation of the roster system. Now, one of the most important requirements of the roster to operate is a yearly recruitment of 3 sources. If there is no yearly recruitment of 3 sources, then the implementation of the roster is bound to cause practical difficulties and problems. Therefore, in Malik Mazhar, your lordships had actually laid down a time schedule as to when the recruitment is to be made. And if that time schedule is adhered to and the recruitment is made in all sources, from all sources within the year, then in my respectful submission, the roster will operate and the roster will fully satisfy the aspirations of all the 3 batches. Now, 2 or 3 more things. First, your lordship said, how would the roster operate? Since the percentages for direct recruitment, promotees and merit promotees is to be worked out on cadre strength, the roster has to operate on cadre strength and cannot operate on vacancies. This is clearly stated in para 29 of the 2002 judgment. It is also clearly stated in Sabharwal, on which para 29 relies on. I have only half an hour, Lord. I will put all this in a small note and because this is over yesterday, I have improved a lot of things. So the roster firstly has to operate on posts. Now, Sabharwal says that when you start the roster, you start, every roster says 211, 211, 211. Now, when you start the roster, initially, obviously, the entire cadre is available to you, and then you start and you proceed. Now, the second point is, why should the persons be fitted at the roster point, at the slots? That is very important. Because once you fit the persons at the slots assigned to each category, every category will then get a representation in every 4 slots in the cadre. There will be no bunching. You will have 2 promotees, 1 direct, 1 limited in every 4 slots of the cadre at every stage. So therefore, when you then proceed to give any benefit of the service, whether it is a senior scale, a super time scale, or even deployment as a principal district judge, when you sit down to make the zone of consideration, within that zone, every person in every slot will be available. So my respectful submission to your lordships is that the solution which was given in the 2002 judgment, and in states where the roster has operated, there is no disparity. In Delhi, the disparity is because up to today, there is no roster. In fact, in the judgment of B.S. Mathur, your lordships in para 52, which in my written submission I have quoted, categorically said, we are now doing length of service, but from 6 onwards, please bring back the roster. Delhi has still not brought back the roster, even up to today. Even up to today, there is a length of service which is going on, and roster has been only brought back if direct recruit and promotee is appointed on the same day, only then. That is not a solution. It has to be a year-wise running account, which is necessary for a proper settling of the equities of all concerned. Now, my lord, so far as the principle of weightage is concerned, which is being argued before your lordships, there are 3 reasons why I say weightage should not be given today. First is, my lord, your lordships originally, when appointment to the post of additional district judges were made, there were only 2 modes of recruitment. Some did not have direct recruitment. It was either promotion or direct recruitment. The Shetty Commission records some states had 60-40, 75 promotee, 25 direct. Some had 2/3, 1/3. your lordships then rework those quotas to give a 25%, and I'm borrowing the words from the 2025 judgment of your lordships, my lord, to give an accelerated promotion within the cadre of the civil judges. So that accelerated promotion was given by carving out this 25% limited departmental quota so that they could work, so that they could proceed in a slightly faster fashion. This is a facet of weightage which has already been given to them within the cadre. The man who would have to wait has one option of accelerated LCD and proceed further. Second, now this argument becomes all the more important because now your lordships have given within the junior to senior also an LCD. So now, actually speaking, and hypothetically, it may not happen, if at 24 I pass my law, 3 years I wait, 26 I get appointed as a civil judge junior division, then another 3 or 4 years I get promoted, I take the LCD and become a senior division, then another 4 years I will have to wait. By 34, 35, even within the promotion quota, I could be eligible to become a district judge. So therefore, my lord, this what you have granted, this what your lordships have granted to them now, to move from the lower junior to the senior scale by way of an LCD is also a sort of a weightage or an acceleration which is granted to the brighter of them, as Mr. Dwivedi had put it, that if a person wants to be patient and take the longer route, then it is, of course, each person has his own aspirations and his own thinking. So this is the second thing. The third now, your lordships have also opened the direct recruitment route to the subordinate judges. So therefore, if your lordship sees a subordinate judge who joins, first has an option to go in for direct recruitment. Then he has an option to take the LCD to move faster from the junior to the senior scale. And then he has another LCD to move from the senior to the ADJ scale. So therefore, my lord, now giving them another benefit of weightage, in my respectful submission, is not the solution. This is the second point that I'm making. The third reason for not giving them weightage is that your lordships in the 2002 judgment para 30 have categorically said that weightage should not be granted and roster is the solution. And therefore, my submission on the first point being, roster has not failed actually. Roster has never been given a chance to, actually a fair chance to operate fairly. And for a roster to operate fairly, yearly recruitment is a must. So therefore, if your lordships is giving some directions, then the directions would be that the observations made in Malik Mazhar for yearly recruitment should be scrupulously followed. That is my second submission. Now, my lord, so far as quota is concerned, so far as quota is concerned, my lord, I can do no better than reading paras 44 and 45 of Muhammad Shujat Ali, my lord. If your lordship will just have that judgment, because that is what is ultimately in Khosa, my lord, of Khosa, the Lokinath Khosa, that is volume 5A, if your lordship will have at page 49, Placitum B, C, and D.
That's at 21.
But your lordships is coming back at 2 or is it?
No, yesterday only.
Yes, but then there was some circular which confused some of us. That the bench will assemble on Wednesday for the day or something like that. Didn't say for the day, it said bench will assemble, so we thought perhaps.
No, your lordship indicated that only till lunch today you will.
Yes, yesterday only.
Before rising, your lordship.
So can I then get 10 minutes on the next, 10, 15 minutes on the next?
You decide amongst yourself timing.
No, 10 minutes only. I have hardly taken 15 minutes. I got a slot of, only 10 minutes on the next day, whichever next day your lordship is granted. Tuesday.
5-7 minutes, you can.
Lord, let me get it on the next table, Lord, 10, because,
They will not take 10 minutes, you'll take more.
no,
Yes.
I promised to take 10 with a maximum of 15, Lord. It's, I'll just recapitulate and
Get Wednesday, Thursday, Friday.
time will
Saturday,
not
Sunday.
change. Time will not change, Lord. I will not take extra.
Lot of time to get your ammunitions, you know.
Grateful.
Your Lordship, there's been a fresh IA that has been filed. IA number has still not been given. If the court could allow, because the registrar is.
Maybe defect, you find it out.
Okay.